it's actually quite interesting. The Supreme Court made, according to the three liberals on the court and Amy Coney Barrett, I mean, she didn't specifically object, Barrett, but she didn't join the other five right-wing crackpots on the court in making this argument. Basically, what they said is that the 14th Amendment is all well and good. Where Section 3 says that you can't serve in political office if you've participated in an insurrection or given aid and comfort thereof. But it only counts at the federal level if Congress passes legislation or, passes legislation. Those were the words in this decision, saying so. Which is really interesting because Congress never passed legislation enforcing the 22nd Amendment. The 22nd Amendment was passed in 1951 because Republicans were all freaked out that Franklin Roosevelt had served 4 terms. It says a president can only serve 2 terms. Well, Congress never passed legislation enforcing the 22nd Amendment, which means, according to the logic of today's decision, that Barack Obama could run for president again. Let that sink in. According to today's decision, Article 2, Section 1, Article 2 of the Constitution says the president has to be a natural-born citizen. Congress has never passed legislation enforcing that, which means that, Cenk Uygur, who's running for the Democratic nomination right now, who was born in Turkey, I believe, could run for president or could hold the office. I mean, in fact, I think Cenk is challenging this. And here's where it gets really weird. This is from an attorney, national security attorney, Brad Moss. He says, so under this court's analysis, if Trump wins but Democrats take the House and hold the Senate, Congress can invalidate Trump's victory and throw us into chaos. Oh, goody. He said it places the burden on federal district attorneys, because there has to be, this federal prosecution of Trump. It places the burden on federal district attorneys who are appointed by the incumbent president to somehow initiate a civil action against the incumbent president for holding office in violation of Section 3. This way madness lies. And Sotomayor, Kagan, and Jackson all agreed. All three of these, the progressive women on the Supreme Court said, we concur on grounds the court goes too far in deciding, we concur on the grounds that the court goes too far in deciding future possible cases. And Amy Coney Barrett similarly said that the court shouldn't opine that federal legislation is the only way to enforce Section 3. So she wanted to leave it to the courts, or apparently. But, and not only that, Clarence Thomas sat on this case. Clarence Thomas, whose wife was participating in the insurrection. This court has just lost all credibility.